As already noted, the General Court Martial and other military courts are all subordinate courts. See Attorney General against Uganda Law Society, Mulenga, Justice of the Supreme Court. However, I do not agree with the finding in the Attorney General Uganda Law Society that the General Court Martial is subordinate but not lower than the High Court. That is self-defeating. It's contradictory. That it is not lower than the High Court and enabling it to handle offenses at par with superior courts of record. Assigning the ordinary English meaning to the word subordinate, all courts martial are subordinate courts created under 129(1)(d) can only have jurisdiction that is lower than the High Court. Holding that it is subordinate but not lower than the High Court is contradictory. It actually makes no sense. It is illogical and has the potential to create an absurdity when it comes to the hearing of capital offenses. Should Parliament desire to grant them the jurisdiction to handle capital cases, then it will need to do so in line with the Constitution. With this finding, the hearing by all courts martial of offenses within the jurisdiction of the courts of record is unconstitutional under the Articles 28(1), 44C, 128(1), and 129(d). I hereby find that Section 1, 177, 117H, 1H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offenses within the General Court Martial and other military court tribunals. Basing on this analysis and finding, grounds 1 and 4 of the appeal would fail. Upon examining the objective of the law and the authorities cited, I find that the impugned provisions of the UPDF Act are overbroad and rationally connected to the broader purpose. The trend in democratic dispensations, especially in the new democracies such as Uganda, which witnessed gross human rights violations in the past and reminds itself of its ugly past in the preamble to the Constitution, a sober decision has to be consciously made. Sections 2, now 1, 170, now 177, and 119(1)H, now 117H, 1H, that allow the trial of persons subject to military law for all offenses under other enactments without any qualification is overbroad. The need to maintain discipline is no justification for the trial of members of the UPDF who are within the country by the military courts, and yet there is a functional judiciary. Any disciplinary action on an officer can be affected after a finding of guilt by the ordinary court. I hereby find that Sections 2, now 1, 179, now 177, and 119(1)H, now 117(1)H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offenses within the General Court Martial and other military courts tribunals. Basing on this analysis, as I've said, grounds 1 and 4 of this appeal would fail. Having made the findings that the provisions of the UPDF Act that confer powers on the military courts to exercise judicial powers are unconstitutional, there arises the consequential issue of the fate of those who, at the time of this decision on unconstitutionality of the UPDF Act, are facing charges or undergoing trial or have been tried and convicted before or by the military courts. This issue was neither raised nor canvassed at the hearing of the appeal. So this court has not had the benefit of counsel's opinion on the matter. Nonetheless, it is a matter of great public interest, hence this court has to deal with it. Issues concerning the extent to which judicial adjudication has retrospective effect, especially regarding a finding that a law or act is inconsistent with the Constitution, is not novel. See Duke Mabea and A against the governor of Abba Hill Prison, whose citations are given. Two rules have been developed which have gained universal recognition and application. First is that once a law has been declared unconstitutional, then applying the principle of direct review, the declaration has a force of retroactive application. Where, however, the accused person was convicted under a law that is later declared unconstitutional and has either exhausted the appeals or has not pursued any appeal, the matter is taken to have been concluded. In such circumstance, the declaration of unconstitutionality of the law has no retrospective application. In retroactive application of new rules, there is a difference between civil and criminal cases. We are here concerned with the latter. Whether a decision announcing a new rule should be given prospective or retroactive effect should be determined at the time of that decision, as this one here now. Thus, there is a further difference between criminal cases on direct review and those on collateral review. Direct review concerns those criminal cases where the person seeking relief arising from the new rule has not yet been tried, is undergoing trial, has been convicted, but is still pursuing a direct appeal, while collateral review refers to those cases where the criminal defendant has exhausted all direct appeals, if any. I cite the authority responsible. In Uganda, the Constitutional Court in Mabea case and American jurisprudence link letter case cited, United States Johnson case, Griffith Kentucky case, Stovall Deno case, and the court cited this and came to the conclusion that retroactivity should depend on, one, the purpose of the new rule, two, the extent of reliance on the new rule, and three, the effect on the administration of justice of the retroactive application of the new rule. The decisions following link letter laid down how this rule would apply to pending cases and those on appeal under direct review. The current American position elucidated in an annotated constitution prepared by Congressional Research Service at the Library of Congress and quoted in A against Governor of Abba Hill Prison, stated as follows, open quote. The court has now drawn a sharp distinction between criminal cases pending on direct review and cases pending on collateral review. For cases on direct review, a new rule for the conduct of criminal prosecution is to be applied retroactively to all cases, state or federal, pending the direct review or not yet final. Thus, for collateral review in federal courts of the state courts, criminal convictions, the general rule is that new rules of constitutional interpretation announced after a defendant's conviction has become final will not be applied. Thus, application for habeas corpus based on a judicial decision subsequent to a conviction becoming final and not otherwise under direct appeal or review fall into the category of collateral review and therefore not entitled to rely on new rules of constitutional interpretation. This principle is apparently not novel to our modern time, as Cicero is credited with having coined the maxim, summum ius summa iniuria, variously translated but classically as the strictest application of law is the greatest injustice. This general principle regarding the effect of declaring a legislation unconstitutional was succinctly stated by Murray J. in A against the Governor of Abu Hill Prison as follows. In a criminal prosecution, where the state relies in good faith on a statute in force at the time, and the accused does not seek to impugn the bringing of or conduct of the prosecution on any other grounds that may be in law open to him or her, including the constitutionality of the statute before the case reaches finality, on appeal or otherwise, then the final decision in the case must be deemed to be and to remain lawful, notwithstanding any subsequent ruling that the statute or a provision of it is unconstitutional. The learned CJ explained the meaning of a collateral attack as follows. A collateral attack arises where a party, outside the ambit of the original proceeding, seeks to set aside the decision in a case which it has already been finally decided, all legal avenues, including appeal, having been exhausted, for reasons that were not raised in the original proceedings, but for reasons arising from a later court decision on the constitutionality of a statute. He made a comparative survey and review of various jurisdictions on the issue and found commonality in the decision taken by them on it. He then said, the question of retrospectivity in the form raised here is one which is material to all legal systems. The fact is that at no stage during the course of the hearing of this case was the court's attention drawn to any system of justice in which a finding that a law is unconstitutional, even where this is deemed to be so ab initio, meant that previous and final judicial decision based on such a law must inevitably be considered unlawful and of no effect in law. I'm not aware of any legal system to that effect. Referring to the situation obtaining in the US, said there are transcendent considerations which militate against complete or absolute retrospectivity. Fundamental interest of public policy requires limitation on the retroactive effect of judicial decisions. The legal order and the administration of justice is not one perfect symmetry. As Justice Benjamin Cardozo observed at page 161 in his seminal work, The Nature of the Judicial Process, Yale University Press, 1921, we like to picture to ourselves the field of the law as accurately mapped and plotted. We draw our little lines and they're hardly down before we blur them. Although judicial adjudication do not have retroactive effect, there are important exceptions and restrictions to that effect. A line must be drawn in the interest of justice. The CJ further elucidate on the matter thus. A judgment condemning a statute for being inconsistent with or contrary to the Constitution does not mean that all which was done or decided under the statute prior to the decision on constitutionality is in all circumstances void and of no effect. It is a principle which is, for reasons indicated in the various judicial dicta which I've cited, consistent with the Constitution as a whole. The common law dimensions of our legal system and the legal system of many other countries in which the courts have the same or an analogous power of judicial review of the validity of laws. Then he said, certainly issues concerning the constitutionality of statutes are on a plane higher than the mere common law. They concern questions fundamental to the rule of law, the protection of rights, and the very framework within which, in the words of the preamble of the Constitution, true social order is attained. Normally, those fundamental constitutional concepts, such as the rule of law, individual rights, justice, and a social order based on that rule of law, blend together so that the principles of constitutional justice to be applied to resolve issues may be readily deduced. On other occasions, Some of those considerations may be competing or even conflicting ones, where the courts have to balance those different interests so as to do justice within the framework of the Constitution. In this instance, one may say in broad terms that there is a competing interest between the claim by the applicant that he stands convicted under law which has subsequently been found to be inconsistent with the Constitution as from 1937, and the interest of justice, including the rights of the victim, where he was otherwise lawfully convicted of unlawful carnal knowledge of a 15-year-old girl, in circumstances where, as his counsel acknowledges, the conviction and sentence were not tainted by any want of fairness or injustice. Thus, the effect of absolute retroactivity, for which the applicant argues, in a sense raises competing consideration, which the court has to address having regard to the provisions generally of the Constitution and what Chiej J. alluded to as transcendent constitutional consideration, the public interest, the common good, and social order. In response to the argument that the declaration that a law is unconstitutional, the learned CJ had this to say: absolute retroactivity based solely on the notion of an act being void ab initio, so as to render any previous final judicial decision null, would lead the Constitution to have dysfunctional effects in the administration of justice. In the area of civil law, it would cause injustice to those who had accepted and acted upon the finality of judicial decision. Rights which had become vested in third parties as a consequence of such decisions would be put in jeopardy. The application of a principle of absolute retroactivity consequent upon a declaration of unconstitutionality of an act in the field of criminal law would render null and of no effect final verdicts or decisions affected by an act which at the time had been presumed or acknowledged to be constitutional and otherwise had been fairly tried. Such unqualified retroactivity would be a denial of justice to the victims of crime and offend against fundamental and just interests of society. I find these authorities quite persuasive and applicable to the current situation, because the constitutional rules declared touch on the fundamental aspects of a criminal trial in a democratic dispensation. In the present case, we have those who have been charged, those undergoing trial, those convicted and in the process of challenging such conviction, as was the case in the Lieutenant Ogwang case supra, and those whose conviction is final. This is the situation of the obtaining with regards to those who have been defendants in the courts martial. I consider that the first three categories that fall under direct review can without any difficulty take benefit from the rules expounded herein as regards trial in the courts martial. However, for those whose trial is completed or who are also referred to as those on collateral review, it is my considered opinion that they fall within the exception enunciated above. In the event, I will make the following declarations. 1,